to our timely webinar entitled Whither, the Intersection of Religious Free Exercise and Anti-Discrimination Laws, a rapid response to Fulton v. City of Philadelphia, which is sponsored by the ABA section of Civil Rights and Social Justice. This panel is one of many that we have in a series on rapid response webinars. We're actively planning additional programming on a variety of issues, so please visit us at americanbar.org/CRSJ for updates on upcoming programs. During today's program, we encourage you to ask questions of our panelists through the Q&A section function and not the chat function. If you do not see those controls, please ensure that your screen is not idle. We will address the questions, time permitting, at the end of the program. We'll be sharing a recording of this program for everyone who has registered so that you can share it widely on your networks. And with that, we are thrilled to introduce today's panelists. Holly Holman, General Counsel and Associate Executive Director, Baptist Joint Committee for Religious Liberty. Chip Lupu, F. Elwood and Eleanor Davis, Professor Emeritus of Law, the George Washington University Law School. Mark Rienzi, President, the Beckett Fund for Religious Liberty. Camilla B. Taylor, Director of Constitutional Litigation, Lambda Legal. And our moderator for today, Richard Fulton, Senior Scholar, Religious Freedom Center, Freedom Forum Institute, and the co-chair of our Religious Freedom Committee of the ABA section of the Civil Rights and Social Justice. He is also a council member of the ABA section of Civil Rights and Social Justice. So Richard, please take it away.
Thank you so much, and greetings to our distinguished panelists. I will just make some brief introductory remarks. Some 10 years ago, as the momentum began to accelerate toward recognition of same-sex marriage, accompanied by extension of anti-discrimination laws for LGBTQ people, we began to see the emergence of symposia and articles on the implications of such measures for protection of the free exercise of religion. Concerns on this issue were cited by some as the basis not to move in that direction at all. There were also not a few advocates who, even as they strongly supported same-sex marriage and enhanced protections against discrimination, also raised questions about those implications for free exercise, particularly with respect to religious institutions. Indeed, the American Jewish Committee's amicus brief filed in Windsor, disclosure I was affiliated with AJC at the time, both urged the court to recognize same-sex marriage as a constitutionally protected right and urged the court to make clear its commitment in future cases to protect the religious liberty of churches, synagogues, and other religious organizations that refuse to recognize same-sex civil marriages. And sure enough, following Windsor and Obergefell, the two key marriage equality cases, there has been a steady stream of cases, some reaching the High Court, testing the extent to which religious exemptions should be afforded to anti-discrimination laws. And as reflected in Masterpiece Cake Shop, and in the case we're about to discuss, Fulton against Philadelphia, the court has rendered narrow decisions, leaving the most vexing questions for further review. So to state the obvious, same-sex couples rightfully seek to and deserve to live in a society that does not discriminate based on sexual orientation or gender identification, and to be treated with dignity and without stigmatization. So also, as Justice Kennedy reminded us in his opinion in Masterpiece Cake Shop, are adherents of perhaps now unfashionable faiths to be treated with dignity and not be made into pariahs. How do we square that circle? So let's turn to the case under discussion. And to do that, and let me also mention that the issues before us in this case today are not only about the case itself, but also about the standards by which free exercise claims should be judged more generally. So we're going to hear, I think, about the case, but also about what this all means in terms of the controversy over the Smith case, which Dr. Fatts can expound on. So, Mark, let me turn to you first. Let's play first year law school. So I'm going to ask you, please, to state the case. What is this case about? What are the issues at stake? What were the issues at stake? How did the court rule? And how does that fit? How do you view that ruling, both in terms of the narrow finding of the court, but also how that relates to the Smith case that I just mentioned?
Great. Thanks, Richard, for teeing that up. Thanks, everybody, for having me. And thanks for scaring me with the thought of thinking back to being a first-year law student. Let me just start with my disclaimer, which is I represented the petitioners in Fulton. I represent a lot of other parties in religious liberty cases. I have a lot of employers. I teach at a couple different law schools. My views today are my own. Let me start kind of where Richard started with the developments over the past 10 years in cases like Obergefell and Bostock and related to gay rights, and then Masterpiece and Fulton. Let me flash folks back to a comment the court made last year in Bostock, the Title VII case. They said, "We are deeply concerned with preserving the promise of free exercise of religion enshrined in our Constitution. That guarantee lies at the heart of our pluralistic society." So, one might look at cases like Obergefell and Bostock on one hand and see the court advancing same-sex rights, and then look at Masterpiece and Fulton on the other hand and say, wait, is this in conflict? Let me suggest that I don't think the justices think they're in conflict. I think what the justices have been trying to say for quite a while now is that we can really have both and. We really can have gay rights and religious liberty for people who've got a different view of sex and marriage. And that brings us to the case that was before the court that they decided last term, Fulton, which was a 9-0 decision in favor of the religious foster agency and the foster moms who worked with it. So the background, the Catholic Church has been providing care for orphans and foster kids in Philadelphia for a couple of centuries. As has happened with many areas of life in the past 50 plus years, the government has gotten much more involved. And for the past 50 or so years, the government has said, well, if you want to do foster care in Philadelphia, you need to do it with a contract with the city. Catholic Charities has done that for 50 years, and it had been fine until 2018. There had been no conflict. But Catholic Charities said it wouldn't do the home studies. It wouldn't go into people's homes and give its endorsement of a particular home as a good place to put kids. It wouldn't do that for unmarried opposite sex couples or for same-sex couples, whether unmarried or married. Catholic Charities didn't say it was going to tear up anyone's application or it was going to reject them. It was just going to say, you know what, the Catholic Church has teachings on these things that are different from your views, and it'd probably be better if you just went to a different agency, and there were many others in town. The dispute is entirely hypothetical because no gay couple ever actually asked the Catholic Church in Philadelphia to come into their home and do that home study. But when Philadelphia found out about this in 2018, they promptly said that they were cutting off all foster care referrals, not only to the agency or to newly approved couples by the agency, but also to any other foster parents who had previously been approved by and were working with the agency. And that's how the case involves both its namesake, Sharon O. Fulton, and also Tony Sims Bush and Cecilia Paul, who was a former foster mother of the year, but who passed away before the decision. But these are all foster moms who have cared for a lot of children over the years. And they were saying, look, I'd like to still be able to work with my religious agency. The lower court said it was fine for Philadelphia to cut off Catholic Charities and cut off these foster moms. Even though the city was in the midst of a foster care crisis and needed more homes, and even though these homes had empty beds and approved parents who'd done a great job over time, the court said it was fine for Philadelphia to cut them off because of a case called Employment Division versus Smith, which Chip will probably have a little more time to talk about than I will. I'll just tee it up. Smith is a decision from 1990, which said, generally speaking, that if the government has a neutral and generally applicable law that happens to burden your religion, that doesn't get any special scrutiny. Essentially, as long as the law has got a rational basis, if it's neutral and generally applicable, it will be permissible. The lower court said under Smith, Philadelphia won. But then we got to the Supreme Court and we see this unanimous decision going the other way, right? All 9 justices saying, actually, Catholic Charities and Sharon O. Fulton and Tony Sims Bush, they are right. It was illegal for Philadelphia to shut them down and refuse to send children to them over this dispute. Let me first start with the unanimity. I think the unanimity is really important, frankly. This was not a nail biter of a decision. This is not a decision that should make good lawyers say, well, let me go back and tweak one more fact, and then maybe I'll pull 1 or 2 more justices my way. This was 9-0. There were 0 votes to say that what Philadelphia did here was legal. And again, I think it shows that the court meant what it said in Bostock last year, where it said that it views the free exercise clause as important in the heart of a pluralistic society. I disagree with Richard's and others' characterizations that the decision is narrow. I actually think it's quite a bit broader than people are saying. And I disagree with the suggestion that some folks have made that Philadelphia could easily work around this decision. I'll note that Philadelphia's press release the day of the decision said they look forward to working again with Catholic Charities. So I hope they won't try that. But let me briefly just tell you why I think the decision is significantly broader than many folks have been saying. If you look at the court's reasoning for why it said this law, the Philadelphia's approach was unconstitutional, they said, well, a law is not neutral and generally applicable if it allows for individualized exemptions. And Philadelphia's contract reserves the right to make exceptions in the discretion of the government. It's important to look at the court's reason for why it thinks making exemptions is a problem. And what it said is that the problem is that such laws, quote, invite the government to consider the particular reasons for a person's conduct. That when the government's going to sit there and say, well, if you had this reason, it would be okay, but if you have that reason, it's not okay, that would trigger strict scrutiny. I actually think it's pretty hard to devise a foster care system that isn't going to bump into that type of discretion. In other words, I think the government is always going to allow agencies to decide that some homes are homes we want to work with and some homes are ones we don't. And I think the government, when running a foster care system, it's, as the court said elsewhere in the opinion, it's a heavily customized and sensitive and case-by-case kind of process. It just doesn't really lend itself to one-size-fits-all rules of the kind that might still fit within Smith. Other things about the decision that are frankly quite broad and important. One, the court rejected the argument that foster care was a public accommodation. This had been a winning argument for Philadelphia below. It's an argument that's been tried in a lot of places, but I think it's important that zero justices, actually thought this was a public accommodation, that Philadelphia could say, well, it's the same thing as buying a cup of coffee or a ticket on the train. They said it's not. The court said that strict scrutiny needs to be done with a focus on, does the government really have a compelling interest, not broadly in non-discrimination laws, but specifically in denying that person or that entity an exemption. And then the court unanimously said that Catholic Social Services was not trying to impose its religious beliefs on anyone. And I think that's also important. Most of the cases in this area that are attacking religious liberty say this is about imposing religious beliefs. I say I'm about the end of my time, so I'm not going to get to my Smith point, but let me just end with this one. I think it's important to look at this case and focus on the unanimity and focus on what the court said and say, look, ultimately fighting against religious agencies in this space is a losing battle. The court is going to say that we have room for people that have a different view about sex and marriage and to continue participating in society. And therefore small tweaks or finding another vehicle, frankly, are not likely to result in a different outcome. They're likely to result in, I think, frankly, more wins for religious liberty. So I hope ultimately people take the court's lead and we can stop the conflict.
Well, thanks very much, Mark. And let me say, you're well situated to start law school all over again because you did such a great job presenting the case. Let me turn now to Holly Holloman. Holly, I wonder if you could, first of all, talk, maybe you're well set now to talk to us a little bit about Smith, expand on it a bit, to talk to us about how the position that the BJC took in this case reflects your understanding of whether or not that was a desirable framework for us to think about exercise cases. And also, of course, what we think in terms of the decision, how far-reaching it really is. Is it in fact as broad as Mark is suggesting?
Sure. I have a few notes on the decision, but I think I would start with agreeing that the court is serious about free exercise, and this continues, of course, a trend toward deciding in favor of religious claimants, regardless of whether we all would agree on whether that was the right decision for religious liberty or not. And also that they avoid deciding too much. And I think that goes to both what Richard said in the outset, but also what Mark recognized, in that this court can both support same-sex marriage and religious objections. And I think it's difficult in finding exactly how that operates in different contexts. So I think that's the challenge. And it was a challenge for BJC in this case. BJC filed a brief joined by other Christian denominational groups on the side of the city of Philadelphia. And we did that even though our brief, again, restated our opposition to the Smith rule, because it has been criticized, and we have criticized it for 3 decades for being insufficiently protective of free exercise. Our brief also acknowledged and held up the positive role of religious organizations in partnering with government agencies. And yet we filed on the side of the city because we think that even under a stricter rule, strict scrutiny, that in the context of a government contract, the factors the court should look at between the burden on religion and the compelling government interest and how they're tailored would weigh in favor of the city. Obviously, that's not what the court found. The court didn't reverse. We thought the court didn't need to address Smith to rule for the city, and the court found they didn't need to address Smith, to rule for Catholic social services in this case. I'm sure Chip will have more to say about Smith, but I wanted to set that up just to be clear that Smith has been criticized by people across the board, and that didn't necessarily answer what we thought was the right decision in this case. I think I would let me just make a few comments. The first thing I would note is about the surprisingly unanimous result in this decision. Mark emphasized that. I don't blame him at all. But I will say it was surprisingly unanimous in that these issues are hard fought, and there are important interests for religious people, religious objectors to same-sex marriage, as well as, of course, important interests in protecting equality for LGBTQ people. And when I say that it was surprising, it's that while the 9-0 decision may be important, it's also, I think, important that the court did not get to that 9-0 result in the way that Catholic Social Services and many of its allies urged, or the way that Philadelphia and many of its allies feared. And by that, I mean, first, of course, the court did not reverse Smith in a case about government contracting for an exclusively government function where the religious organization is authorized to act based on a delegated government function. I say all that, that's the context in which we saw the case, that it was in this government setting, and it would have been, in our view, a particularly bad way to revisit Smith. Secondly, the court did not suggest that religious opposition to same-sex marriage necessarily creates exemption to non-discrimination laws. So this court, having recognized religious objections to same-sex marriage now in a few cases, did not create a blanket exemption. And so in that way, I think I would respond to those, or can understand those who would say this decision is narrow. And I also understand Mark saying it's not. So we can debate that. What the court did do, the second observation, and why it is maybe viewed as narrow, is that the Roberts opinion really focused on the contract provision that allowed the commissioner of the city's Department of Human Services to grant exemptions. There's not a lot of a discussion about what that exemption provision is for. I thought, based on oral argument, what I heard, it was presumably about making sure the child is placed in the right home among qualified, or between qualified, certified foster parents. As I understood it, there was no evidence the exception had ever been applied, certainly not to any contractor to refuse to work with any couple based upon their protected categories. But that said, it was enough for the court to find that the contract was not generally applicable and therefore not subject to the more restrictive rule of Smith that would deny exemptions from neutral laws of general applicability. I'll just make a couple other notes. In applying strict scrutiny, the court, as I said before, BJC has criticized Smith. We led the coalition that supported RFRA. We want free exercise claims to be taken seriously before the court. And as I said, we looked at this context as the burden and interest playing out differently. In this case, we don't get much about the court. We don't get much about strict scrutiny and how it works. The court was very deferential on the question of burden and accepting the burden on Catholic Social Services. Granted, they've been involved in helping orphans and neglected children for many, many years, and I think the court recognized that. That doesn't mean, however, that the burden is the same when they are doing work actually certifying who can be a foster parent. That's not something you can do in your own ministry with your own private funds, but it relies on the delegation of a government function to them. But the court didn't really engage very much in that burden. In how that burden was articulated, but accepted it very, very easily, saying that the certification was tantamount to endorsement. So as if it was forcing the city to violate its religious scruples. In doing that, the city, the court didn't talk about what the city established. What people on the city side established, which is, the city was not interfering with their beliefs in a religious setting or their ministry with their private funds. So I would take issue with that. And then secondly, on the government interest, the court did not do a thorough review of those interests and how they played out in this setting. There are several interests, and I'm sure Camilla will talk more about them, but the one that was most prominent, of course, is the equality for all citizens, and particularly the dignity and equality of foster children and potential foster parents. And while the court noted that interest was weighty, it did not seem to give much concern for how that was protected in this particular environment. So that's what I see what the court did. I think in the end, the Fulton decision, it's important to note that it does not require courts to create religious exemptions in government contracts or in non-discrimination policies in general. But you certainly will look for opportunities. The court will be looking for opportunities too, and where that might be required. And I just would reiterate that non-discrimination serves a very important role, particularly in this context of government contracting, where we all come to our government as equal citizens without regard to religion and should be treated the same. And I would, my main concern is how this decision will affect, how it will continue to be applied in the context of government funded services, and how it might influence other religious claims that could affect services. And maybe the facts were more important here than the court really explained to us, as Mark said, because of things that hadn't happened, because of the number of contractors. But the court did not make that clear. And so I think we are all, can be concerned about the implications in other government contracting situations.
Yeah. So I'd like to turn now to Camilla, and really picking up on the themes that Holly was just talking about, namely what are the implications of the policy that was upheld. What is it about this case that raises concerns of the LGBTQ community? How do you see those concerns about anti-discrimination intersecting with religious accommodation, and how, to what extent we should allow for religious objections, and to what extent, and I guess the final thing I want to ask you is, to what extent do you see grave problems in where the court has left you now versus perhaps the structure and the framework within which you can still operate and assure fair treatment of members of the LGBTQ community?
And thank you very much. It's an honor to be included in this panel, and I appreciate the opportunity. So we at Lambda Legal, it probably will surprise no one, agree with Holly that this was a relatively narrow ruling, and part with Mark on that point. In our view, this was based on an idiosyncratic provision in the Philadelphia child welfare system that Philadelphia easily can fix, that established that the commissioner, in her sole and absolute discretion, could exempt entities from the non-discrimination requirements in Philadelphia's city code. And because it was based on this unique provision, it left advocates on both sides to fight another day on many of the big issues. So agreeing with Holly on a number of other things, what the decision did not do. So it did not require religious exemptions or accommodations in government contracts or grants for services to the public when they are subject to a neutral and generally applicable non-discrimination requirement. It did not overrule Smith or otherwise address the level of scrutiny that would apply to a case involving a neutral and generally applicable non-discrimination requirement in government services. And it really gave short shrift to the question of whether the equality interests would be sufficiently compelling to overcome a request for religious exemption or accommodation in those circumstances. It acknowledged that those interests are weighty, but it didn't go further than that because of the sole and absolute discretion that the commissioner had to waive non-discrimination for any reason, which undermined any equality interest that the city could assert. The court, though, has spoken about whether there's a compelling justification for non-discrimination with respect to public accommodations and LGBT people relatively recently, though. And in 2018, in Masterpiece Cake Shop, the court had an opportunity to review a claim brought by a baker who wished to refuse to serve same-sex couples for their wedding in the marketplace and claimed a religious objection to doing so. And in Masterpiece Cake Shop, although the court again resolved the case based on some unique factual circumstance in the case and the court's conclusion that there was hostility to religion expressed by a commissioner below, the court did say a number of things relevant to its conclusion. We believe that these government justifications in favor of non-discrimination are sufficiently compelling. The court said it would be, quote, unexceptional that Colorado law can protect gay persons just as it can protect other classes of individuals. It found that Colorado's anti-discrimination law was a public accommodation law that was neutral and generally applicable. And it also said that the general rule that actors in the economy and in society, that's a quote, cannot get exemptions from neutral and generally applicable rules that require them to give equal access to goods and services based on their religious and philosophical objections. And most interestingly, it cited to a case Newman versus Piggy Park as justification for these conclusions. And that was a signal that this is not new. The request for religious exemptions from neutral and generally applicable non-discrimination laws. We've seen this as every new marginalized community steps forward and asks to be treated equally with respect to government services and in the marketplace. And again, the Supreme Court has ruled that those sorts of religious objections are not a sufficient justification for non-enforcement or exemption from non-discrimination laws. And Newman versus Piggy Park was a barbecue joint where the owner wished not to serve patrons of color and argued a religious justification for doing so. And the Supreme Court determined that that was a frivolous objection and it was insufficient. The court more recently in Roberts versus JC's found that there's a compelling justification for enforcement of sex discrimination, even against important First Amendment considerations in the associational context. So there are many precedents that come before with respect to communities other than the LGBT community specifically, where the court has established this rule. And what's happening now is that we're finding in the wake of important decisions like Obergefell, as Richard noted, that religious entities often receiving huge amounts of government funding to serve the public are saying that a new rule should apply to them now because they have objections to serving same-sex couples. I'll say just quickly, there were a few things that were not present in this case that will be present in future cases and will allow for elucidation of some of the principles that I'm suggesting were not resolved in this case. There was no establishment clause claim in this case. And as Mark mentioned, there was also no evidence that a same-sex couple had been turned away. And most importantly, the purpose of child welfare programs that care for foster children is to do what's in the best interest of the children who are in government care. And their interests were not elucidated in any satisfactory degree. There was no child in that case. And there was no exploration of what happens when you have an agency that refuses to acknowledge that LGBT people exist. And what happens when they are serving children in government custody? What happens when a child, say at the age of 13 in foster care, comes out and is under the care of such an agency? How will that child's best interests be served by a government-funded social service agency that refuses to acknowledge the existence of LGBT people? There are a couple of cases in the pipeline that will amply be able to put some of these questions forward. One of them involves a couple in Texas that sought to apply to be foster parents, and they were told by a subgrantee of the United States Conference of Catholic Bishops that receives millions of dollars to perform federal foster care services for refugee children. This couple, a lesbian couple, a same-sex couple, were told that they were ineligible to apply because their family, quote, did not mirror the Holy Family. There is significant evidence in that case too, that the agency refused to acknowledge that they had any LGBT children in their care, or that there could ever be a. So I think we will see more exploration of these issues in future cases, and more demonstration in records of the grievous harm that can befall not just the foster parents who are seeking to participate in this program, but also the children who are in government care.
Thanks so much. So we turn now to Chip Lupu to bat cleanup for us. And, you know, I guess what I'd like to, it's been a lot of mention of Smith, and perhaps along with telling us what you thought of how the court interpreted the current law, and what, especially particularly with respect to what was supposed to do about the standard of generally applicable laws, perhaps also help us understand you know, whether the structure we're now in is a good structure, that is, it's not broke, let's not fix it, or rather, is it time for us to be thinking about other approaches to religious exemptions in the context of regulations and ordinances?
Okay, thank you, Richard, and thank you for setting up that question, and thanks to my panelists, co-panelists here. I will talk about Smith and its future, its past, its present, and its future. First, I want to say a few things that I sort of noticed haven't been mentioned, or they've been sort of, you know, gestured at but not focused on. You know, Masterpiece Cake Shop a few years ago, and now Fulton, they showed the signs as they were arguing in the Supreme Court of being major battles in the culture war that we're talking about here, about LGBTQ rights, same-sex marriage on one side, religious freedom on the other. They turned out when the court decided them not to be major battles, they turned out to be skirmishes. And we do see that the religious freedom side won both skirmishes, but the major, and you know, one was about bias in the process, and this one's about discretion in the commissioner's office in Philadelphia. But the major battle about what happens when these kinds of values get put squarely against each other, the Supreme Court has not resolved it. And it's still there to be fought. The other thing no one mentioned, and it's something that Justice Alito picks up on at the end of his long concurring opinion. It was 7.5 months between the time this case was argued, the day after election day in November, and the decision in the middle of June. 7.5 months. What took so long? The court opinion is only 15 pages. Justice Barrett's concurring opinion is only 2 or 3 pages. Well, Justice Alito has a 75-page concurring opinion. So part of what was going on, there's every reason to think, was a major battle behind the scenes about what was going to happen to employment division against Smith. Was it going to be overruled? Was the court going to say, even if the state's policy or the city's policy is generally applicable and religion neutral, and I think in this case they were, all social service agencies had to follow the rules about non-discrimination in screening prospective parents. So the question was whether there was going to be a right of free exercise exemption to what looked like a religion neutral, generally applicable rule. And I think in the end, there was a veneer of unanimity in this case, right? As they all agreed, tip of the hat to you, Mark, your side won. But I think there's every reason to think that the court was divided something like 3 to 3 to 3. Alito, Gorsuch, and Thomas. Let's overrule the Smith case. Barrett, Kavanaugh, Breyer, well, maybe, but not so fast. We're not ready to do that. And Roberts and Kagan and Sotomayor, they're just quiet about it. So 7.5 months, there must have been a lot of fighting between Sam Alito and his group of 2 others to try to find a 4th and a 5th vote to overturn Smith. And maybe Barrett and Kavanaugh were their best shots, and they didn't get it in the end. They spent months and months and months working on it, and they didn't get it. So let me talk a little bit more about why they didn't get it. First, there's a very curious phenomenon here about almost no one defending the Supreme Court's decision in employment division against Smith. It was a cert question whether the court should revisit it. And yet even the city of Philadelphia didn't say, oh yeah, Smith is great. We won. We win under Smith. Let's keep Smith. There were a lot of people arguing the way Holly argued. Oh, it doesn't matter. even if it's overruled, the city should win anyway. I was in a group of 4 scholars, Bill Marshall, Bob Tuttle, Fred Geddix, and me, arguing that Smith was right and should be reaffirmed. And we were kind of lonely voices here, right? There were so few voices on that side. So maybe we're goofy and we have a strange and indefensible view, or I don't think that, of course, or for 30 years, we've been in this world where people say, well, there's something wrong with Smith. It's illiberal. It's insensitive to religious minorities. People on the left and the right and the middle, they're not comfortable with it. And then people fight about what we should do. But there's a lot of objections to it. Now, you know, I was part of this effort and still am to say, all things considered, the Smith rule and its corollaries is still the best possible approach. And I understand sometimes it's going to be insensitive to vulnerable minorities. That's a dilemma. That's not a reason to throw it out. Justice Alito has a 75-page critique of employment division against Smith. Bob Tuttle and I are about to publish an article about Fulton, where we spend a lot of time criticizing Alito's mistakes. But let me just highlight the leading mistakes that he makes, in his opinion, and we can talk about them more later as we have time. Number one, Mark and CSS offered, and they've done this, Beckett Fund has done this for years. They have what I consider a highly misleading narrative about free exercise law over the last 230 years. They want to treat the Supreme Court's decision in Sherbert versus Werner in 1963, Wisconsin versus Yoder in 1972 as central and normative. That should be the free exercise rule. Smith was a departure from it. Smith is wrong. We should go back to what the true rule should be. And what they ignore is the 170 years from 1791 up to 1963, where there was not this strict free exercise rule, and the 30 years after Smith, where there has not been this strict free exercise rule, and the 27 years even between Sherbert and Werner and Smith. Justice Alito 3 times says it's 37 years. I'm sure his arithmetic is better than that. It's 27 years. He wanted to exaggerate the time. Even in those 27 years, the court worked around the strict rule over and over and over again. So the idea that we should treat those 27 years and that combination of opinions, some favorable to religion, some not, as normative and guiding, it seems to me just wrong. Beyond that, you know, Alito says the text and the history of the free exercise clause support his view. And I think he's just wrong. The text, he trots out dictionary definitions of exercise of religion. And there's a general definition. It means performance, like a performance of a musical exercise. But there's a religion-specific definition from 18th century dictionaries. Exercise of religion is public worship, right? The meaning of the free exercise clause originally had to do with protection of beliefs and public worship. That's what the dictionary definitions support. And the history of the free exercise clause focus on the 17th century in England, 18th century in the colonies, and then in the United States. Free exercise protected worship and belief, not all religiously motivated actions. This is the misstep that leads us into the great 20th and 21st century dilemma about the scope of free exercise. If it means all religiously motivated actions, then for some human beings, that's everything they do in life is religiously motivated and religiously guided. And if all of that is covered by the protections of the free exercise clause and protected by the strict standards that Alito contends for, the system is completely unworkable. This is what Scalia meant in Smith when he says it would make every believer a law unto himself. In the 18th century, the free exercise meant freedom of belief and worship. Now, you might think, oh, come on, it must mean more than that. We all think of it as meaning more than that now. But in the 18th century, that was a big deal. In the rest of the world today, the idea that everyone has equal freedom of belief and equal freedom of worship is a big deal. And that was the clause's original meaning. When Alito goes into the peace and public safety clauses in the state constitutions, when he says, oh, we know we know that free exercise is broad and you can only limit it when it threatens peace and public safety. He's jumping over the major question, which is what free exercise religion was. It was freedom of worship, and the peace and public order, public safety provisions were there because in the 18th century, there were itinerant preachers who were coming into town, who were being disruptive, who were challenging settled preaching of Protestant preachers. Some were Holly Smiling, some were Baptist, some had other denominational connections. And they sometimes were a threat to public order. They come to town and worship in the street. They would worship in unruly ways. Perhaps they disrupted other worship services. So the public order and safety provisions were there to make sure that everybody had freedom of worship, but not to disrupt the worship of others and to cause disorder when you come to town. And when we get to the 19th century and the Second Great Awakening and the idea of religious conviction infusing all, it takes on a different coloration. Maybe a non-originalist interpretation of the free exercise clause goes way beyond freedom of worship alone. Then you just need to grapple with what free exercise of religion is. But as an original matter, it's not what Sam Alito says. And I think that's where he goes astray. And I think Justice Barrett, my last word, Justice Barrett sees that Alito has not answered the concerns that Scalia expresses in Smith about an expansive free exercise doctrine. Justice Barrett was a Scalia clerk. I don't know if she read our brief. She read the opinion in Smith very carefully, and she was not going to cross Antonin Scalia and his view unless she was persuaded. 7.5 months later, she was not persuaded.
Thank you, Chip. As I turn to the other panelists to see, to give everybody an opportunity to respond briefly to comments that other of the panelists have made, I can't help but remark that whatever the history, and I wouldn't question your scholarship on this for a moment, Chip, where we are today, the notion that exercise is mere worship is a very, Protestant-centric, forgive me, but Protestant-centric view of religion. And we're in a very dire place vis-a-vis a pluralistic society if we don't acknowledge that constitutionally protected accommodation of religion, whatever it means, the protection of the exercise has to mean more than just protecting worship. That's essential to all the members of minority faiths in this country. So let me open it up before we go to Chip. You're welcome to respond if you want, but to all the panelists, if anybody wants to, in a minute or two, respond to some point they heard that they would like to say a word about.
I'll just say one thing on that particular point, on Chip's point, and Richard, your response. I agree that we are beyond any time of thinking that we're just protecting just religious worship in the most narrow sense. And I get very tired of the harsh partisan arguing where people say, "Oh, you don't care about religion. You just want me to keep it in my house and keep it in my church." And I don't think that's really fair. I think the problem is, as Chip describes, how do you decide how far free exercise goes? And I tend to think about the context instead of the exact claim, because of course there are people who would claim that everything they do is religiously motivated, and you can't expect the same outcome for all of those claims. The way that I put it when I was being critical of the court's strict scrutiny, their application, and something I wrote was just, the court didn't grapple with this question of can any sincerely held religious belief by itself establish a government burden on religion? I mean, that seems kind of broad. And and shouldn't there be some balancing? If you give totally into burden, if burden's really easy, should it make compelling interest less hard to make, something to make this make sense because we want it to make sense so that it can work? And secondly, is there some legally significant distinction between religious objections to same-sex marriage and other religious objections, such as to interfaith marriage? I think that's a really a question the court has really tried to avoid. I think, Camilla was getting that in what she was stating, and I don't, agree. I don't agree. I don't have to judge everyone's religious views. I'd rather not assume the worst or where people are coming from, but just to recognize that there are a lot of religious distinctions, religious feelings and distinctions that people have. And I don't think we've made much progress in this case on understanding, whether this is really just about same-sex marriage or something broader. I think the court has tried to avoid, obviously, the broader rule, and we heard it in the oral arguments in this case, and we certainly heard them in oral arguments in Masterpiece.
Yeah, if I could just jump in, Richard, for a couple of quick minutes, just a few assorted responses. One, from our point of view, we did urge the overruling of Smith, but it was not our lead argument. Our lead argument is the one that the court accepted, which is that Philadelphia broke the law even under Smith, which we do think is a bad standard, and I'll get to in a second. But our lead argument was we win because what Philadelphia is doing breaks the law any which way you look at it. And 9 justices ended up agreeing on that point. And I agree with Chip, the 75-page Alito opinion makes you wonder what took the 7.5 months, given how short the majority opinion is. I suspect, to the extent you can read anything into those opinions, it was fighting over Smith. It wasn't fighting over whether Philadelphia broke the law. There were 9 votes that said that under any understanding of the free exercise clause, what they did was illegal. As to RFRA and Justice Barrett, Chip, I don't at all think you're a goofball. I think you're a very smart guy. But the view you're pitching of Smith found no takers in this set of opinions. At least no takers who wrote it out. I grant you there may be people who who hold your views about Smith and didn't pick up the pen to defend the decision, but they did. And I grant you, Justice Barrett said, I'm not ready to overturn Smith yet, but she and Justice Kavanaugh also said that in their view, the textual and structural arguments against Smith are more compelling. So you've got 5 justices right now who I think the textual and structural arguments against Smith say the decision was wrong. And just, we'll figure out how much time we get to go back and forth on things, but let me just make one substantive response on Smith. Scalia's lead argument, or at least a big piece of Scalia's argument, is the one Chip gave, which is if you do this, this is going to be anarchy. This is going to be every man's conscience is a law unto itself, right? And he gets that line from Reynolds, the case saying that the majority can decide that marriage is just 2 people and can put people in prison for pursuing any other view. The problem I see with that argument is just RFRA, right? Like since 1990. At the federal level, we've had RFRA. I'm sorry, 1993. At the federal level, we've had RFRA. We've had RLUIPA for prison and land use cases. We've had lots of states with RFRA laws. It's just not anarchy. We've all lived with it for the past 3 decades. So it actually hasn't caused anarchy. It's caused some isolated religious exemptions, but it hasn't caused anything like anarchy. Most of us drive between RFRA states and non-RFRA states all the time, and we never turn to the person next to us and say, wow, now it feels like anarchy over here. It's not anarchy. It works just fine, and it has for decades. So to the extent Scalia thought that was true in 1990, I don't think it's plausibly true, and I certainly don't think any of the justices who've decided these RFRA and RLUIPA cases could believe that to be true. They may have other reasons, but I don't think that could be the one.
Anyone else want to jump in before we go to questions?
Yeah, I want to say a little bit about things that that others have said. Let's start with you, Richard. I mean, first of all, of course, you're right, and I saw Holly nodding and others nodding, that the idea that exercise of religion is only about belief and worship is, as you put it, Protestant centered. And we are a religiously pluralist country. No one wants to suggest that somehow in the society other religiously motivated activities and exercises don't deserve respect as religion and religious beliefs. Of course they do. There's still a question about constitutional meaning. So if you're an originalist, I think what I was saying was right. If you're a non-originalist, you say the idea of what counts as exercise of religion has expanded over time, expanded in the 19th century, further in the 20th and in the 21st. And then you're in a dilemma. And then you're in this dilemma about what's covered and how you protect it. And here I just want to add one little dimension to what's been said so far. And that is the way complicity claims, Masterpiece Cake Shop, Fulton, other cases like this involve complicity claims where someone says, oh, well, even though I'm free to follow my own faith about sex or marriage or family life, I'm in a relationship of some kind with somebody else. They work for me. They want to buy something from me. They want my social service, charity, attention in a case like Fulton. And I have objections to what they're doing. I don't want to cooperate with them. I don't want to give them a platform or them a support. So when you add complicity claims to the rest of the picture, you were really, and they arise in all these various relationships, you are extending the possibility of imposition of a set of religious concerns on others much more than you would be without complicity claims. Now, Mark says, and I've heard it before, oh, well, we have Religious Freedom Restoration Act. We have a federal one, applies only to the federal government for the last 25 years. We have state ones, the world hasn't fallen apart, the sky hasn't fallen. Part of that is because the federal RFRA was not really interpreted very aggressively until about 10 years ago. And mainly Hobby Lobby really pushed it much more aggressively, remains to be seen. But that's limited to federal law. And half the states have Religious Freedom Restoration Acts. Half of them don't. A lot of them have been interpreted in ways that are, let's say, gentler than their terms. Courts have worked around them. And that's part of the story of free exercise of religion and religious freedom, is that you could have strictly religious freedom protecting rules, but if courts don't like the way they're going, they're going to find a way to work around it. Or you could have Smith, which is not such a religious freedom protecting rule. And here in Masterpiece and in Fulton, you find the court finds a way to work around that and protect religious freedom more than the law seems to allow. So there's, I thought for a long time, there's a lot of lawlessness in this enterprise. And that's part of what troubles me about the way the conversation has gone.
Thank you. Kamala, you were the only one who didn't weigh in after the discussion, so I don't want to move on without giving you a chance if you want to say something.
Thank you very much. Well, I would love to respond to the notion that somehow RFRA has been in existence and none of us even recognize it or feel it day to day. And I think if you have a uterus and you change employers to an employer that's claimed an exemption under Hobby Lobby, you notice. And certainly for LGBTQ people who may move from jurisdiction to jurisdiction, some of which have public accommodations laws that protect them from discrimination, some of which don't, some which have state RFRAs. And I agree with Chip that we're fortunate that many of those have been interpreted in pretty limited ways. You notice these are things of which you were aware. And until the Bostock decision in the last term, it was certainly very relevant to LGBTQ employees, which jurisdiction they lived in, because there were some federal circuits that had not yet interpreted Title VII's protection from discrimination to apply to LGBTQ employees. And therefore it was very relevant if their employers were in a jurisdiction that were likely to make certain claims, including based on religion, as justification for discriminating against them. So these are obviously issues that affect marginalized members of our community a great deal. And the use of First Amendment claims, whether it's free exercise or compelled speech, whatever it is, as justifications to be exempt from neutral and generally applicable non-discrimination laws will hurt people.
Thank you. I know I have a couple of questions I'd like to ask, and then we'll turn to questions. We've gotten a few questions in from the viewers as well. So the first thing I want to start with is, of course, one of the big differences between Masterpiece Cake Shop and Fulton is that Masterpiece Cake Shop had to do with a person that was in commerce, operating a private for-profit business, versus Fulton, which has to do with a social service provider that's religiously affiliated. And of course, there are many religious institutions around the country that also, to a greater or lesser extent, want to be able to act in accordance with their religious tenets. Should that make a difference in how we think about protecting religious liberty in these contexts? To be more differential to religious institutions, given that there we're talking about not just about individuals who may be in commerce, but in fact about the institutions by which individuals come together to congregate and express their religious fellowship in a way that they just can't do on their own, and which most religious leaders would say is essential to their ability to exercise the faith. So what do we do with this issue of religious institutions, religiously affiliated institutions, individuals, in terms of what the First Amendment may or may not require in terms of religious exceptions?
Let me say a word, okay? First of all, Justice Barrett raises this question, just as a question, in her concurring opinion: should we treat religious institutions differently from individuals who are religiously motivated? So, and we know there have been cases in the last 10 years about the ministerial exception from civil rights laws, which I have defended in my scholarship, right? There are plenty of people who I agree with about many other political things who think I've got this backwards, or I've defended the ministerial exception as involving questions that are ecclesiastical: who's fit for ministry, who's not fit for ministry, and in which the government should not intervene or should not regulate. But there's a difference between internal matters, like who's fit for ministry in a particular faith community, or who's entitled to the blessings and sacraments within a particular faith community, right? Absolutely, faith communities should decide for themselves who gets their blessings and sacraments, including marriage. It's quite different when a religious institution reaches out and interacts with others outside of itself. Now, Catholic Social Services in Philadelphia was doing that, participating in the city's foster care program. Religiously affiliated hospitals serve the community. They don't serve only people of their own faith. They serve the community. They get lots of money from Medicaid patients and Medicare patients, and they are public utilities in many ways. Now, they have a religious identity, but how we're going to figure out how much autonomy they're entitled to because they have a religious identity when they're out in commerce and healthcare, in relation to the government and its funding streams. It seems to me that what we do with internal religious community matters should not control what we do when religious entities reach out into the community in those ways.
And I guess not surprisingly, so a couple things. One, on Richard, on your original framing question, I would just point out, Hobby Lobby was actually now 7 years ago. And everyone said the sky was going to fall then, and the sky has not fallen. And Camilla mentioned that if you switch to one of those religious employers who doesn't cover some contraceptives, you may notice the difference and you may suffer. I'll just point out the contraceptive mandate has been to the Supreme Court 3 different times as a merits decision. And there have been like 80 or 90 amicus briefs opposing the religious people. And you know what brief never showed up, like not once, is an actual woman saying, I was unable to get this contraception because of my religious employer. The world is awash in contraception. It's actually easy to get. Every government's dying to give it out to you. And again, like that was a decision decided 7 years ago and nothing's happened. To Chip's point about religious institutions reaching out, I agree. That's where a lot of the friction is right now is, okay, religious groups don't just stay within the 4 walls of the church. They go out and they have schools in which they try to take care of as many kids as they can, often kids who don't share their faith, or they run foster care programs, right, where they have both foster parents who don't share their faith and foster kids who aren't their faith, like Catholic Charities in Philadelphia does. They have hospitals and they care for the sick of every stripe and in any way you can imagine. That's all true. And it's also true that even though all of that was church work for thousands of years, in the last century, in a lot of ways, it's become government work too. Philadelphia tried to argue here, well, you're doing government work, therefore we get special control. And again, there were 0 votes for that. So I actually don't think it's all that likely that the court is suddenly going to turn around and say, well, you operate a school or you operate a hospital. So you operate a hospital, therefore you have to give up that religious piece of your identity of not doing the abortions because you operate a hospital and you know what, you care for poor people and we give you money when you care for poor people. So you have to give it up. I think we'd really be a much poorer society if we told all the religious groups, well, you get to be religious and stick to your faith until you step foot outside the door and do this other stuff. And then when you do, you've given it up because the government is so big and involved in so many things. Again, that argument was on the table here. There were just 0 votes for it.
Hollywood, did I see that you wanted to say something?
No, I mean, I can say that, Mark may be right about this court, but it's extremely uncomfortable from a religious freedom perspective to think that we can't distinguish between churches and the work that they do in their own community with their own funds, making their own choices about how inclusive or exclusive to be, and exercise of religion in a setting through a school or a charity that gets government funding where expectations are quite different. And, maybe this conversation will continue and things will develop where there's more understanding, but I do not think that people have the same expectations when they come to get a government service that they would have if they walked into a Catholic or Baptist church, as far as how they are treated and what their expectations are. And similarly, I think there's some difference in even going to a religious school. I mean, often if they're religious schools, many of them now, really trying to get government funding, really trying to appeal to get more students, beyond their faith, and they may, we see this. We see a lot of gaming, I think, of the system going on, and so I just think it's more problematic than Mark says. Not because religious people shouldn't go beyond their church. I'm from an evangelical perspective. Go out and preach and try to bring people in. But I think I do think that the law should be able to make some distinctions based upon different contexts. Different kinds of religious institutions to protect religious liberty differently, and I think that we'd be better off that way, not poorer for that.
So if I may just ask a follow-up question. So I gather then, if we're dealing with a parochial school that is entirely privately funded, or for that matter, an adoption agency that doesn't take government funds, that just operates with its own funds to serve the community, that those would be areas where perhaps government regulation should not be enforced in the same way as it would with a funded organization?
Maybe have stronger arguments for that. I think that most people could see a distinction that when religious entities are seeking government funds and seeking to do a government function, and I appreciate Catholic Charities, and I could tell from the record, from what I could see, it looked like appreciation from the city of Philadelphia. They've got lots of contracts with Catholic Charities, so there seemed to be a lot of respect for the religious work, and even religious perspective. Is just the question of whether they could take their religious principles and their views about marriage and change a contract, an expectation of non-discrimination in that government program. I think that it looks different.
Thanks. So I want to ask the last question for me, and then I'm going to turn to the participants. And this is really directed towards Mark and Holly more than anyone, because you're the folks that want to, in some respect, overturn or reduce the impact of Smith. What would you substitute for? I mean, really asking Justice Barrett's question. If we get rid of it, what are we going to replace it with? Do you have any ideas that can be expressed briefly, as opposed to more of the article, as to what we would replace Smith with?
I'll go quickly. I'm sure, Mark, yours is more well developed than mine. So let me just go real quickly and say that we've said strict scrutiny, but as my comment said earlier, I don't think it was applied correctly. I think part of the issue on reversing Smith is that time has passed, and these other things have kind of taken its place. So maybe Smith doesn't seem as horrible as it seemed, and we all said at the beginning, as far as its everyday implication. So while we've said strict scrutiny, I think I'd be very interested when that case comes and people are briefing it and putting all the different ideas and maybe articulating that in ways that maybe are better understood than many of us have assumed.
Okay. Anybody else? Oh, I'm sorry, Mark.
Yeah, I'll just give a quick answer, which is, look, I think sometimes the court has gotten itself in trouble when it's tried to answer all of the questions with one test to rule them all. I think in some ways that's the problem with the Lemon case in the Establishment Clause. And I think in some ways that's the problem with Smith. Like, I think sometimes it's like this juicy idea that maybe we can come up with the one test that will apply regardless of the context and in every circumstance, and then it'll be easy and we'll be done. And I think that's kind of fool's gold. And I think it was fool's gold for Lemon and Smith. And I suspect here it might be too. I think there are some circumstances, like what Chip mentioned, it's like the ministerial exception, where you'd say there's a religious exemption and there's no balancing test. In other words, there's just no government interest you could put on the other side to say that the government gets to pick the rabbi. Like, we don't do balancing at all after that. If it's about picking the rabbi, government just doesn't get a say, period, full stop. There are other things, I think a lot of things, frankly, for which you'd want something like strict scrutiny. I think what's wrong with Smith is that Smith says, even if the government's forcing you to violate your religion, the government doesn't really need to show anything. There's nothing for them to prove. And I think that's always been the problem with Smith. And what we need is actual enforcement of the constitutional provision. And let me just say, there's another reason I think Fulton is a big deal. Between Masterpiece and Fulton and the COVID cases, you get this patchwork now, and it is a patchwork, but you get a patchwork where you can get to strict scrutiny in a lot of different ways. If there are exemptions, if there's discretion, if there's government bias. Well, I actually think a lot of government action has a lot of discretion and a lot of exceptions, and frankly, a lot of government bias. So I think the truth is we can call each of those narrow paths, but when you put them together and look at the way government acts, I think it actually gets you to strict scrutiny, at least a decent amount, certainly more than you did 3 years ago.
Thank you. So we've got a lot of questions that have come in, and so I'm going to have to just choose a couple. I think one that's interesting is this really has to do with judge counting. So maybe we'll start with Chip on this one, which is the fact that we have a unanimous court here, really the product of realpolitik. That is, the liberal justices decided that if they didn't go along with a majority opinion, they were going to wind up with something far more sweeping and problematic from their point of view. And so they got a decision that was, something they could live with versus something that would be wrong. So, just a comment from you or anyone else on how we got to this unanimous decision.
Someday we'll have Justice Breyer's papers or Justice Kagan's papers. It'll be like 50 years or 30 years after they die. So maybe none of us are going to be around to see those papers. Someday we're going to have papers. There's going to be some discussion about what happened behind the scenes in those 7.5 months between oral argument in Fulton and decision in Fulton. And yeah, of course, we can all speculate. And it's quite plausible to think that there were 2 or 3 dissenters, right? There were 2 or 3 justices, Justice Sotomayor most likely among them, was going to say, no, the city of Philadelphia should win this case. And we should keep Smith. It's important. And was going to answer Justice Alito and at great length. Okay. And that somehow some deal got bargained out. Maybe Roberts is very good at this, right? And he bargained out and he went to the possible dissenters and he said, look, there's going to be 6 of us. They're going to join this opinion. We're going to rely on this discretion clause. So this is something that cities can control. They can have discretion to make exceptions or not. So this is a skirmish, and the city's going to lose this one. But the cities have some control going forward. So join with me on something that makes this into a skirmish. Don't write a dissent. Justice Barrett will stay with us and not go off with Sam Alito. And yeah, we can certainly imagine there was that kind of a deal. If you read the transcript of the oral argument, they were 3 to 3 to 3. There were 2 or 3 of them who were going to dissent. We're going to rule from the city. And they somehow, I don't believe they were entirely persuaded by the argument that they joined, but okay, they joined it. So that's right. It's 9-0. We can't second guess it once they sign it. But yes, there were some behind the scenes compromising that we would love to know more about.
Anybody else on that question? We'll move on then. I also have a question here, really asking about the relationship of the establishment clause to the fixed clause in this context, which is to say, shouldn't the establishment clause be read as somehow protecting recipients of government contracts from having discriminatory practices imposed on them? They in effect become agents. This is the question is asked. They in effect become agents of government, and therefore it's an establishment clause violation to ever allow a funded organization to engage in a discriminatory determination as to who's going to receive services or be eligible for a particular program. So I'll ask that question. I would like to respond.
I'm happy to, unless Camilla, I figured you might want to, so you want to go first? Okay. Let me answer the broad version and then the case specific version. The broad version is, I don't think that's the way the establishment clause works. In other words, I don't think it's an establishment of religion for the government to work with lots of different groups, some religious, some not. I think that view of the Establishment Clause, went away a few decades ago, and the court hasn't been there in a long time. And I think that's quite right. In this case, Philadelphia's contract really, really repeatedly insisted you are not an agent of the city. And that's right. Catholic Social Services is not the city's agent. They are an agency that provides a service that the city needs and likes and that benefits a lot of poor and minority children. But they're not agents of the city. They're not government actors. They have crosses on the walls. They always have. That's okay. Governments are allowed to partner with religious groups without making the religious groups into the government. If the opposite were true, then when kids take their Pell Grants to religious colleges, and when religious hospitals take care of people using Medicaid and Medicare funding, that would all become the government. I don't think there are any takers on the court for that, and with good reason. None of that establishes any particular religion. It just says the government is, working with all the people in society, some of whom happen to be religious. That doesn't establish anything, and no court's ever, no Supreme Court has seriously thought that way in at least 35 years or so.
And unsurprisingly, I disagree. We are bringing Establishment Clause claims in a number of our cases that are challenging government funding of faith-based agencies, where those faith-based agencies, with the consent and the complicity of government, are turning away beneficiaries of those programs based on religion. And that's based on a bunch of authority that says that the Establishment Clause is violated if government endorses religion in a way that harms third parties or coerces vulnerable people. And even in Trinity Lutheran versus Comer, where the Supreme Court found that a program that a tire resurfacing program for playgrounds that was secular in nature should not have excluded churches on its face. It went out of its way to say that the program that was being funded there was a playground for kids that was related to a school, was non-discriminatory in nature. So once there is discrimination and government is aware of it in its funding, that raises very serious concerns when that discrimination is based on religion.
What else? It's also a question here about what's the burden on a religious person to prove that they are sincerely religious. I mean, perhaps this is a somewhat of a moot point if we're talking about Catholic social services. It's hard to imagine real argument as to whether or not acting is at least sincerely religious. But the question is, what's the burden of proof that somebody has to show that they are religious and not using religion merely as a basis to discriminate, as opposed to seeking to exercise some real religious belief?
Yeah, I don't think you get religious exercise rights unless you have a sincere religious objection. And I think it's fine for courts to look at it, and they frankly do look at it in appropriate cases when they wonder whether they're looking at someone who's got a sincerely religious objection rather than something else. So this comes up often in the prison context. 50 years ago, it came up in the draft context where people might have an incentive to falsely claim a religious belief. As Richard pointed out, there's no real argument, no claim that Catholic Social Services was insincere here, just like there's no claim that Little Sisters of the Poor or Hobby Lobby were insincere, because I think everybody who looked at it could tell these were sincere people. And so the folks on the other side didn't waste any time making that argument. But if you have someone who you think is insincere, it is certainly available to the court to say, I don't think that's a sincere religious belief. Again, courts, there's a long record of courts doing that and finding some things to be insincere, just not these cases.
I want to add one thing. It's kind of going back to the previous question that Mark and Camilla answered. And I think, I agree with Mark that, of course, participating in a government program doesn't make a religious organization the government. And there's a long tradition of partnerships, although I have to say it's changed, of course, as the government's grown and all. But that doesn't mean, and the court, of course, has recognized that government can work with different religious institutions, but it doesn't mean that then the religious organizations can alter the program as they did in Fulton under the circumstances of this case, in a way that prevents services. And that's what we haven't seen. And this case was not well developed for that. And I think I heard Mark say and others say they would just refer them to someone else, but I don't know that we had the facts of that case. And I know from experience in other cases that that has not always been the case, that a religious exemption, that a religious claim was easily met because you can just do it somewhere else. Instead, as we saw in the contraceptive mandate, it kept being a different kind of objection. And that's part of why those cases kept continuing. And so it really brings me to the last, I've already brought up the questions in my complaint about the court, about the, can any sincerely held belief, establish this high burden, and the question of other religious claims, not just LGBTQ, objections to LGBTQ non-discrimination, but other things. But the other big question is, would the requirement of a religious exemption to a non-discrimination rule depend on the availability of other providers? And that's what the court did not get to here. And it's easy to say, oh, and maybe that's why the court was able to decide the way they did, is because they weren't that concerned in this case, even though they didn't make that very clear in the opinion of the case, which would have been helpful.
So actually, Camilla, I'd like you to respond to this. Does it make a difference that you can just go down the street, there's another foster agency, walk away, that will be perfectly happy to, interview and certify a same-sex couple as proper parents? So what's the harm, if any? I know what the answer is going to be, but what's the harm, if any, in allowing Catholic social services not to serve that couple because somebody else is easily able?
The court has recognized in numerous instances that there's a dignitary harm to being turned away because of who you are, because of something that you can't change by your government, or by an entity that's performing government services, or by anything that's subject in the marketplace to a non-discrimination law. And it's recognized this in the context of all sorts of forms of segregation. The availability of another water fountain is not okay, or another military academy that the state claims is going to be completely equal and will have an effective alumni network. It's just not okay. And the court, in a number of different cases, like Sweat versus Painter and Brown versus Board of Education, has talked about how even if you make the physical resources identical that are available to children in these segregated schools based on race, the children will know in their hearts and in their minds that there's something different about them that the government considers relevant in that segregation. And the court has recognized these dignitary injuries in all sorts of different contexts, including in Obergefell versus Hodges, where the court recognized that the injury of being excluded from marriage was felt not just by the couple themselves, but by children who are being given a message from their government that there is something wrong with their family when their government excludes their parents from marriage. So these dignitary injuries long have been considered relevant and important, and they're real to people. They hurt.
I think Camilla and I have now found the one spot where we're going to agree, which is I think dignitary harm when the government excludes you can be real and hurtful too. I just think where we disagree is where the harm is coming from. In other words, I think if the city of Philadelphia says to you, hey, you're welcome to participate here, but you got to leave aside that bit of your Catholic identity and you've got to sign on and endorse something you don't agree with. And if you don't, you're out. I actually think that's serious dignity. That's the government saying you're a bigot, you're not welcome here. To turn that around and say we're also going to regulate the behavior of private entities is something that in the First Amendment context, we just haven't done. So, in Obergefell, that's the government excluding people, right? That the court was talking about there. And the government exclusion parallel in Fulton is not Catholic Charities saying, hey, look, we're Catholic, we're not the right people to do this for you. It would be the government saying, hey, if you want to be authentically Catholic, get out of my program, because that's what Philadelphia was doing to them. And our client, by the way, in the case, Sharon L. Fulton, who's a Black woman in Philadelphia, said she's never felt discrimination like she felt from her city government over this.
I think we're down to the last question. So in responding to it, this might be also a good moment for folks to make whatever concluding remarks they'd like to make for a minute or two. And this question really, picking up on this theme of who's being excluded, it's an interesting one. It asks, is there a need to discuss how the growth of government affects or reduces the scope of permissive religious acts? In other words, we have, the 19th century, state and church didn't butt up against each other very much. they really were in their own realms. And as you have increasing social services and regulations from the government, there's more and more of an opportunity for religious actors to be acting in a way that perhaps the government doesn't think is appropriate. Are we heading towards stalemate here as these two important institutions of our country and our concerns, both religious liberty and protecting against harms such as discrimination, are going to make it more and more difficult to reach a proper relationship or balance between these two institutions? So that's sort of a big question statement, a question to throw out as we move towards a conclusion. And then, of course, any final comments that belongs to me.
Well, let me say something brief. That is a big question you asked. Let me say something brief about it. We do have much larger, more expansive government now than we did in centuries gone by a great deal. And we also have a much more religiously pluralistic country now than we did in centuries gone by. So the possibilities for conflict between the expansive government and religiously pluralistic society they get multiplied over and over again. And the question we're asking here, and I want to focus it this way, is not should religious differences ever be accommodated by the government? Sometimes they should. The question is which ones and who should do it? So the Smith rule says, in effect, it is legislatures and executive branch agencies and not the courts under some set of mandatory principles that should decide, work out the benefits and the burdens of appropriate accommodation. It's not, there are no accommodations. We're going to leave it to the political branches to balance the burdens and benefits of those accommodations. And the courts themselves are not going to do it because they're not well equipped to do it. And that's part of the defense of the Smith rule.
Thanks. Who else wants to?
I'll just say it is not,
yeah,
is that, yes, these things have changed. And I think it behooves all of us, if we want to continue to hold up religious freedom as America's crown jewel, to listen to each other, to engage in the difficulties here and how we can accommodate religious objections, as well as ensuring equality, non-discrimination for groups that have been historically kept out of the civil square or services. So I think we have a lot of work to do, and these cases always show us kind of where our limits are, and it just shows us kind of the work that we have to do, educationally in our community, in the policy realm. So I don't have anything that could say other than we have a lot of work to do, and perhaps our calling should be to protect religious freedom for all in a way that really recognizes what we've learned and how we've changed, and these realities of pluralism and its growth.
I invite Mark, Pamela, please to weigh in, whether on this question or just concluding thoughts, whatever you feel like.
Sure, thank you. One of my favorite quotes from Justice Kennedy is from Obergefell versus Hodges, where he says that the nature of injustice is that we may not always see it in our own times. And I think we are in a particularly perilous time for LGBT people because there has been such an advance so fast with respect to recognition of the common humanity of LGBT people, including in the courts, but also in legislatures. And this has prompted thousands, if not millions of people to be more inclusive and brave LGBT people to come out and to affirm who they are and to be authentic to who they are. And as a result, we're seeing a feeling of retrenchment and challenge and some concern from forces who didn't necessarily appreciate the extent to which the rights of LGBT people in the society have been oppressed for so long. And that means this is a period of backlash. This is a period where we're going to have to do a lot of education and to try to make sure that everyone understands what's at stake and who could be hurt. But I do feel optimistic that we will resolve these. And I feel optimistic in particular because of the concurrence from Justice Barrett. Even though there have been a lot of criticism of Smith, there has to be a recognition that the administrability of something to put in its place could come with grave consequences. And that's a concern. And in the meantime, we should work to ensure, just as Holly said, that we have principles that remain in place to protect everyone in a pluralistic society. And that includes those sincere religious belief and also those who are marginalized for reasons of identity.
Mark.
I'll happily agree with a lot of that. So Camilla and I are getting to agreement in the end. Like, I think this case and these conflicts are about pluralism and how we're going to deal with it. And I think, to go with a different part of Justice Kennedy's opinion in Obergefell, he said that what was wrong was the law picking one version of marriage and making people outlaws or outcasts for trying to live out a different view. I frankly think since Obergefell and cases like Masterpiece and Fulton, the shoe is just very much on the other foot, where we've got governments who have their preferred view of marriage and are trying to make outlaws or outcasts or close down programs for people who don't want to go along with that view. So I'm very optimistic. I think the court has been getting religious liberty cases right for a long time. In the gay rights cases, they've been very clear that they see room for everybody. And I think that's wonderful. They see room for both protecting gays from employment discrimination and allowing religious groups to still be authentically religious, not fake religious, like you can be here if you give up some of your beliefs, but authentically religious, even if those beliefs happen to disagree with other people. So I think the country's actually on a good trajectory. I think the court has actually been working quite hard to send the message that we can have things that we disagree about that are really important. And again, in a free society, if we're allowed to think for ourselves, we're going to come to different beliefs about really important stuff. And the court, I think, is saying, you can do that, and there's a way to do it, and there's a way to not use the government to crush people who disagree with you. And so I'm optimistic. I think the court's been doing a good job of that, and I hope that that the court can kind of pull society along with it to have a little more patience and room for people who disagree and have a life and a lifestyle and a way of living their life that's different from yours. I think the whole country could benefit from everyone doing a better job of getting along with people who take a different path than you do.
So I'd just like to close it out by saying we're still at the beginning of a constitutional conversation and a social conversation at how having to assure that we safeguard two very important principles in our society, which is freedom of religion and also protection of all of our citizens from discrimination on an invidious basis, and that assures that everyone, regardless of who they are, is able to live full lives in that society and together with others in the society. And a lot of that depends on our being willing to actually engage in conversation and to hear each other and respond, of which I believe this panel has been a wonderful example of a interesting civil conversation with disagreement on important things, and also, as has come out now, some agreement on also as well on some important points. So I'd like to thank Mark Rienzi. I'd like to thank Holly Hallman, Kamala Taylor, Chip Lupu for your immense contributions in participating in this program. And at this point, I'm going to turn it back to Rama, who's going to take us out. Thank you.
Thank you for joining us for this free webinar. I'd like to express our group's gratitude for our esteemed group of panelists. You're doing such critical work and important work that we thank you for taking time out of your busy schedule to share your experiences and your viewpoints. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at americanbar.org/CRSJ. Best of luck in your work.